So, Simon, by popular demand, people seem to want to know more about the detail of the case. For instance, some of the terminology is a bit confusing to new students of the law. So, just what is a prerogative? How has it evolved? And how have the courts managed to say it's up to them to decide, in this case anyway, whether or not it's been exercised properly?
Yeah, it's interesting. One of the main principles that is talked about around this case is parliamentary sovereignty. But while that is important to the case, it's first and foremost about the court's ability to review what is called a prerogative power. And the prerogative powers are effectively the powers of the executive branch, the government, independent of the law of Parliament and the common law to do things. So they are the residue of what used to be the monarch's powers to do things that are sort of left over and that Parliament hasn't taken upon itself. So one of the main examples of that are lots of things to do with international law and treaties, making treaties and withdrawing from treaties and things like that. And in the first Miller case, that was one of the, that was why it was such an interesting and difficult question for the courts, because on the face of it, it is a prerogative power of the executive to be able to conduct and withdraw from treaties. But in the case of the treaties around the European Union, we have the European Communities Act and UK law, and a very complex integration of the systems. And so whether in that particular case the executive could notify the Union of wanting to withdraw from the European Union, independent of Parliament's say, was up for grabs. But yeah, that's kind of one of the main areas where prerogative power exists, but it exists in a number of different areas. And a lot of the areas are, bordering on essentially political questions and decisions. So the issue in this case about the justiciability of prerogative powers, or this prerogative power to prorogue Parliament, whether the Supreme Court has within its jurisdiction the ability to make this decision is there because proroguing Parliament may be seen as an essentially political act.
Yes. So this takes us to issues about the Constitution. Sometimes lay people rather than lawyers or law students say what we really need is an e-written Constitution, to which the standard answer of a law student or a lawyer would be, well, we have a Constitution and almost all of it is written in one form or another. What you really mean is, should we have a codified Constitution where we set in one document at one point in time the crucial rules, or at least the principles? And the argument against that is, well, it would soon become out of date because you need to keep the law in tune with the times. And for instance, if you'd done it 200 years ago, it wouldn't have included votes for women. But now everybody would obviously think it should do. So that's a debate that goes on. And then there's also the issue that in the particular context of the United Kingdom, some of the magic or aura of the Constitution and of the society seems to be tied up with this long history in which there's been a gradual evolution rather than a revolution or a defeat in war or a complete change in the legal system. And so there is something about adjusting power from, as you said, the monarch to elected politicians over centuries. But interestingly now, the courts, who are unelected themselves, seem to be muscling in on, you can understand it if they were muscling in on the monarch's powers, but it's really the elected politicians' powers in government. So that's the controversy in a way.
And in this case, it's often said in defence of courts in a way they can only deal with the cases that are put before them, and they muscling in perhaps suggests a slightly more proactive stance they have, whereas they could have said this is not justiciable and left it at that, but as to some extent the lower court in England did, but they when they're asked to decide a question, ultimately when no one else can decide
Yes.
it. You know, so they're left to
So they're the decision maker of last resort.
of last resort on the constitution.
But they don't have initiative.
Yeah.
The power of initiative. So a government or parliament can say, let's look at this area of the law, and they can change the law. At least the government can change the law if it can persuade a majority in the House of Commons and then get it through the Lords. For instance, in the last session of Parliament, we had changes in the law which came from backbench MPs on issues including upskirting, which became a criminal offence after a campaign by a member of the public and supported by backbench MPs, and a law requiring house builders to make sure that the letterbox is at a reasonable height so that the men and women delivering the post don't have to bend down and get a bad back. And that was put through by effectively the trade union campaign, which was picked up by a backbench MP. So those are examples of the power of initiative from elected politicians, which gives them much more scope to be creative. So I take that the judges have to wait for somebody to come to them. But in this case, how did they get round that centuries-old tradition of deference to the prerogative powers? And is it a convincing manoeuvre?
Well, there's just on the first point, there's been an interesting development that's been related to some extent having small majority or minority or coalition governments in the last few years, as well as I think some sense that the executive have become too strong within Parliament, and so because the executive obviously in the UK system sits within the Parliament, doesn't have independent elected authority, and so to reassert Parliament's kind of position. So there's been a move to give more time for debates initiated by backbench MPs or opposition parties, and more scope to debate issues that aren't brought forward by the government, and that's been particularly the case recently. We've seen in Brexit with the standing order, question of who controls the business of the Parliament, and ultimately the passage of the Benn Act, the infamous Benn Act. So that is perhaps one reason why the courts were handed this question, because of this fine balance at the moment with a minority government that's losing its minority rule is even decreasing as we go on, and Parliament.
Well, yes. Well, sorry to interrupt, but there's an interesting parallel there to my student days. If you go back to the 1970s, in those days, the left in British politics seemed to be opposed to judges intervening, partly because there was a Labour government for a considerable period of time, and it was losing in the courts. But the answer to that, I think, was it was losing in the courts partly because it didn't really have a working majority, and it was trying to do things by executive power because it couldn't change a statute. And now, at the Labour Party conference, the judges got a standing ovation when news came through that they made this decision. So I don't think judges are deciding in a certain way just because they're from a certain background or they all think in the same way, or to do with their politics or what they think about Brexit. But I think you're right that if the politicians have, or one or two politicians have more power and haven't got a majority to support it, then they will have a higher burden of proof or responsibility put on them by the courts. I mean, the court more or less says that only the Prime Minister effectively can prorogue, but that carries with it a responsibility to have reasons for doing it in a certain way. And as far as they could see, he had no reason, let alone a good reason, I think they say at one point. So if you almost use a prerogative power to its absolute limits, you're going to get into trouble.
Yeah, there are more pressures and tensions in the system. This government is obviously in quite a tight spot in terms of how to achieve its policy on Brexit, and so it has to, it's had to take executive decisions that are unusual or closer to the limits, or and so that has led to them being challenged. So it is definitely a function of the kind of situation we're in, rather than, as you say, judges wanting to have their political.
And another way in which the law edges forward can be illustrated by the GCHQ case in the 1980s. This is where Mrs. Thatcher said, without consulting with the unions at the government communication headquarters in Cheltenham, GCHQ, that national security meant that they couldn't go on strike, for instance. And the courts were asked to review that by the union, and the courts ultimately said Mrs. Thatcher was entitled to make that decision because of national security, but they rejected the idea that they couldn't look at it at all because it was a prerogative power, because they're servants of the Crown. And so sometimes the courts can say, well, we're not going to give a remedy in this case because it's trumped by national security, but we're moving forward and we are saying in principle we would intervene were it not for that.
Yes, and so national security is one of the areas of high policy that the courts are very reluctant to intervene in. But we have seen, as coming out of the GCHQ case and subsequent cases, a gradual willingness of the courts to review certain prerogative powers under certain circumstances, developing over time, and saying, as they do in this judgment, going back in some cases to centuries old previous judgments, that it is the role of the courts under the separation of powers to supervise the exercise of the law by the executive. And so to come back to this question of deference to the government and whether the moves of the court are convincing, they say they sort of take very careful steps. Each one, well, not every one, but in some cases, kind of moving that sort of law that in terms of the ability of the courts to review the prerogative power and this particular prerogative power, and on what grounds they've done so, moving the law forward slightly in some areas and other areas in order to come to this decision while trying to say they're remaining deferent to the sort of political role of the executive to exercise its prerogative power. So, they say that, as I say, that you've said the prerogative is in principle justiciable by the courts under certain circumstances, and then they talk about this particular prerogative power to probe Parliament and the fact that in this case they say it's had an impact on a fundamental constitutional principle,
yes,
parliamentary sovereignty, and that they are only doing something the courts have always done, which is scope the limits of the power and not actually decide whether the exercise of the power within its legal limits was reasonable. They're saying we're just drawing the lines around which the prerogative can.
And this is why this is a great case for new students of constitutional law, because it involves almost everything. And I guess that one of the things we're saying is, as in so many walks of life more generally, a bipolar approach to something, you're either for this or against it, or you're either of this gender or that gender, or this persuasion or that persuasion, that actually there's more fluidity here in the Constitution, and it's not just law or politics, it's not just the prerogative or Parliament or the courts, but actually we have to understand the complex relationships between the different institutions which make up the Constitution.
Yeah, and these sort of binary oppositions, the politics of the day at the moment is increasingly being drawn in these terms. You either Remain or you're Brexit. You're either, trying to scupper the whole Brexit project, or you're trying to definitely leave with no deal. Whereas, and obviously those are the political issues, but in this judgment and in the constitutional questions, you can see a lot more nuance and the careful evolution over time of some of these things that have some extension in some areas in this case, which you can see the development over time in the courts.
Good, so that's a convenient moment to pause, and in our next conversation we need to look at that challenge between fluidity in identity and the Brexit yes or no. But for now what we're saying is that this court judgment is a work of art in a way, whether or not you agree with it, in trying to show how something which you thought was definitely the case, that the prerogative would not be reviewable in certain circumstances, over time that doctrine can become attenuated, or it can be challenged, become weaker, and then in the right circumstances the court will take a bold move, and then we have to see in future cases whether that holds. That's the Constitution.